Hello guys, welcome back to another video. So friends, today in this video I'm going to share with you about the most important topic is of writ of certiorari. Certiorari is one of the writ which is to be filed in the High Court for its grievances, but what is general meaning we can explaining here as to what are the grounds for issuing a writ of certiorari, what is its general meaning, what are the objects of filing it. So firstly, it is a Latin word which means to certify. Certiorari may be defined as a judicial order issued by the Supreme Court under Article 32 and by the High Court under Article 226 of the Constitution to an inferior court or any authority exercising judicial, quasi-judicial or administrative functions to transmit to the court the records of the proceedings pending therein for scrutiny and decide the legality and validity of the orders passed by them. And if the decision is bad, it is quashed. So that's why a prayer is made in the writ of certiorari for quashing of the proceedings, for quashing of the order dated in the case of writ of certiorari. It is also to be noted that the certiorari is now regarded as a general remedy and can be issued even when the action is administrative. In the case of A.K. Kraik versus Union of India, the writ of certiorari was issued to quash the administrative action of a selection board. The writ of certiorari can now be issued to anybody irrespective of the nature of the function discharged by it. The writ can be issued to any constitutional, statutory or non-statutory body or persons exercising judicial, quasi-judicial and administrative functions affecting rights. There are certain grounds for approaching the writ of certiorari. So what are these grounds which you must have to mention in your writ is that the first one is error of jurisdiction. Error of jurisdiction refers to such situations where the authority acts without jurisdiction, in excess of jurisdiction, or fails to exercise jurisdiction vested in it by law. These grounds as mentioned here under, like first one is lack of jurisdiction, second one is excess of jurisdiction, and the third one is abuse of jurisdiction. So where the lack of jurisdiction is then where the authority has no jurisdiction at all to take action. It is a case of lack of jurisdiction. Excess of jurisdiction means where the authority has jurisdiction but it exceeds its permissible limits. It is a case of excessive jurisdiction. And the third is abuse of jurisdiction, is when a certiorari will be issued to quash an action where the authority has abused its jurisdiction. An authority is said to have abused its jurisdiction when it exercises its powers for improper purpose or an extraneous considerations, or in a bad faith, or leaves out a relevant consideration, or does not exercise the powers by himself but at the instance and discretion of another person. Second ground is jurisdictional facts. It is to be noted that the fact or facts upon which an administrative agency's power to act depends is called a jurisdictional fact. If the jurisdictional facts do not exist, the authority cannot act, and where the authority wrongfully holds or assumes that the state of jurisdictional facts exists, although actually it does not exist, such assumption of jurisdiction is liable to be quashed by the writ of certiorari. Next ground is error of law apparent on the face of the record. This is also one of the grounds which says that an error is apparent on the face of the record and which is self-evident and can be ascertained merely by looking into the records without having resort to other evidence. Error of law apparent on the face of the record cannot be overlooked by the courts as it is an insult to legal system. Error of law shall include clear ignorance of law or disregard of law or a wrong proposition of law. or a clear inconsistency between the facts and the law and the decision, and it may also include cases of abuse or jurisdiction or a decision basis on no evidence. Next ground is violation of the principles of natural justice. A writ of certiorari can also be issued when there is a violation of principles of natural justice, and there is a minimum standard of natural justice which must be complied by anyone who decides anything. So this is the general meaning. Now we see what are the objects of filing the writ of certiorari. The object of writ of certiorari is not only negative in the sense that it is used to quash an action, but it also contains an affirmative action as well. The power of judicial review is not restricted where glaring injustice demands affirmative action. In the case of Gujarat Steel Tubes versus Mazdoor Sabha, while quashing the order of dismissal, the Supreme Court held that it can also order reinstatement and the payment of the basic wages. If now generally a question arises in my mind, whether can a certiorari be issued to call for proceedings of an act? So clearly no, because in the case of Pramod Verma versus State of Uttar Pradesh, the Supreme Court has held that a writ of certiorari can never be issued to call for the record or paper and proceedings of an act or an ordinance. So this is the writ of certiorari. For other writs, you may see the playlist of administrative law, where I have already shared the writ of habeas corpus, mandamus, certiorari, quo warranto, and writ of prohibition. So friends, this is our today's concept. Thanks for watching this video, and please share and like the video with others as well. Thanks for watching this topic.